It's great to have you for our first webinar of 2023. My name is Carly Saw. I'm the Director of Strawberry Seed Consulting, and I'm joined by Kylie Simmons, one of our HR advisors. Kylie's up in sunny Queensland today?
Yes, it's sunny Queensland today.
It was sunny Victoria today too, so that's good to know. Though I was talking to someone in New South Wales earlier, and they're up in the Blue Mountains, and it was 15 degrees, and it's raining in Newcastle. So Queensland and Victoria for the win for the weather today. Today we are going to be discussing the IR changes that are coming up. And the sort of things that employers do need to know as we head into these changes that have already started coming into play. As I get my computer to work. So I'd like to start by acknowledging the traditional custodians of the various lands on which we are situated today and pay respect to the elders past, present and emerging. And I'd like to also extend that respect to any Aboriginal and Torres Strait Islander peoples that may be joining us this evening. Just a little bit about who we are. We are Strawberry Seed Consulting. We are a HR consulting firm that work with small businesses right across Australia. Our team is, our head office, I guess, is in Torquay, Victoria, but we also have team members in Geelong, in Melbourne, in WA, and Kylie is now with us for 6 months now, I think.
Yeah, just over 6 months.
Over 6 months, and Kylie is based up in Queensland, so she's an hour behind us at the moment, I think. And we basically work with small businesses right across the country, helping them with everything HR, from hiring to firing and everything in between. So before we start to get into the actual changes that are coming in or have started coming in over the last couple of months, I want to just really briefly touch on the laws that govern the employment in Australia, because I think it's really important to understand how they fit together. And I do find that there is some confusion around this with some of our clients when they first come on board. So I think it's important to cover it off. And certainly anyone that's been on one of our webinars previously will have seen this slide. The thing that underpins employment in Australia is the National Employment Standards and the Fair Work Act. And really the changes we're talking about today mostly are changes to the Fair Work Act, which started to come into play from December when that legislation was actually enacted. And really the Fair Work Act covers all employees in Australia. It is the minimum standards of employment that everyone's expected to meet. The next level is our industrial instrument. So that is can be an award, or it could be an enterprise-based agreement, and that is in place to cover the terms and conditions of employment for employees in a particular industry or a particular profession. And it usually covers things that are more specific to that particular profession or industry. It could be things like span of hours that are considered normal, how shift work is in play, what penalty rates or rates of pay different employees are entitled to. And that sits on top of the National Employment Standards and Fair Work Act, and it really provides more detail specific to a particular area. And the third level is the employment agreement, the written contractual arrangements between employee and employer. This often covers things that aren't covered in the other two levels, but again, it can't be less than those two levels. So it has to provide conditions of employment that are at or better than what are provided in the award and the National Employment Standards. And certainly you can't contract out of the National Employment Standards. So I think that's important because we're going to talk about all three of these today in different contexts. So it's important to understand how they work together. So before I hand over to Kylie, I'm just going to touch an overview on what we're going to go through today. So we're going to talk about pay secrecy, which has already come into play back in December when this legislation was enacted. Paid family and domestic violence leave, which is now in play for large businesses, and small businesses will come into play in August. New laws around sexual harassment, which will come into play from next week. Temporary workplace shutdowns. There is a new clause coming into many awards in May this year. Flexible work arrangements, there's some changes to that are coming into play from June, and then fixed term contracts, which we'll be looking at briefly as we finish up, and that will be coming into play from December this year. So without further ado, I am going to pass over to Kylie, who's going to tell us all about pay secrecy.
Thank you, Carly. Hi, everyone. Let's start off by discussing the pay secrecy changes. So up until recently, it has been standard practice to include pay secrecy clauses in employment contracts. So this is a significant change that has been in effect since December last year. So a pay secrecy clause can no longer be included in employment contracts, and employees can now discuss their pay openly between themselves if they choose to do so. So there is a 6-month grace period. So by June this year, there will be fines issued if any employment contracts have a pay secrecy clause.
Okay, so what should you do next? And I will add in that if you have any questions as we go along, we're going to have plenty of time to answer questions at the end. So please feel free to drop those into the Q&A box, and we will be answering those as we get to the end. But as an employer, what does this mean, and what should you be doing? So first of all new agreements for new employees should not contain a pay secrecy clause. Like, that's something that should be removed immediately from any contracts that you do have. And we've been in the process of rolling that out across all of our support clients. You need to check that any policies and other agreements that you have with your employees, and that could include things like a confidentiality agreement, also are compliant, because sometimes confidentiality is mentioned in other places within our organisation. And so, again, if you have a policy that mentions pay secrecy, or you have a confidentiality agreement that mentions that, that will also need to be removed from there. You need to consider if and when you're going to update your current agreements with your existing employees. And this is an interesting question, because a lot of people are saying, oh, should we be doing that immediately? And the answer is no, you don't have to. You've got a few months to implement this. And as we go through the different areas today, you'll hear us say one of the things you might want to do is to add something to your employment agreement. And some of these things don't come into play until May or June this year. So our advice here is that if you are going to update your contracts, one of the best ways to do that is to do it in line with a pay rise, because employees tend to be a lot more open to signing a new agreement when it comes hand in hand with a pay rise. Obviously, if you don't, you can say, well, if you don't sign the new agreement, you don't get your pay rise in that instance, as long as the person will still be paid legally. But I would also be suggesting that you start now talking to your employees and letting them know, hey, over the next few months, we will be reissuing everyone with new contracts of employment. There's some changes that are coming in, that the government has enacted new legislation, and actually that was the first round. So there is potential for other things to be looked at over the course of this year as well. And let them know, because there's nothing worse or more, I guess, scary for employees. Suddenly out of the blue, you just hand them a new contract and they're like, what is going on? I'm not sure what's happening here. So let them know that that's something that you're looking at, that's something that you'll be doing, that it's in line with some changes that are coming into play, and you want to make sure you're up to date and current. But certainly I would be then also ensuring that, you know, you do it when you're doing a pay rise, because it makes it a lot sweeter for an employee to sign that new agreement. And finally, one of the things that I think is scaring a lot of employers is how are they going to handle this conversation when employees start openly talking about their pay? Because I think we would be naive to think that employees never talk about their pay. They just maybe don't do it as openly. And now there's nothing really stopping them. So it's really a good idea to do a bit of an audit. You know, are you currently got all your employees being paid on parity? Now, we've been in an employment market where there have been people having to pay premiums to recruit people in. So are you in a situation where a new employee might be earning a lot more than a current employee who's at the same level as they are? This could come to play, and employees might raise this with you. So you need to be ready to be and prepared to have these conversations if they arise. So firstly, I would be having a bit of a look to see if there is any inconsistencies in your pay that you might want to address proactively. Also, if an employee does come to you and say, hey, I want to talk about my pay, I feel like so-and-so is earning more than me, you don't have to immediately address that concern. There is nothing wrong with saying, look, thank you for bringing this to my attention. Let me go and have a look into it. Let me have a think about it, and then let's catch up and discuss it. Because then you have the chance to go away to look into it, to see whether there are any issues, to think about how you're going to respond. If there is a reason, you know, not everybody sees the world in the same way, and some people just think, well, I should be on the same as someone else, but there might be a very good reason why they're not. So we can certainly help you have those conversations as well. And we can certainly help you update any of your documentation if that's required. So I'll hand back to you, Kylie.
Yep. So previously, family and domestic violence leave was 5 days unpaid leave. So with the recent change, all employees will be entitled to 10 days of paid family and domestic leave in a 12-month period. So these changes came into effect on the 1st of February this year for businesses with over 15 employees, and on the 1st of August this year for those with 15 or fewer. Now, under the new provisions, family and domestic violence means violent, threatening, or other abusive behaviour by an employee's close relative, a current or former intimate partner, or a member of their household. So family and domestic violence paid leave could include, for example, the employee making arrangements for their safety or the safety of a close relative, accessing police services, attending court hearings, counselling sessions, appointments with medical, financial or legal professionals. So this is a new form of paid leave. It is accessible to all employees. This leave is not prorated. It's available to all employees, including part-time and casual. So paid at the employee's full rate of pay. It's available to access straight away, so it doesn't accrue, and renewing on the employee's anniversary each year. If this leave is exhausted, employees are entitled to 5 days unpaid leave afterwards.
And that's the same as what's in place currently before this is enacted.
Mm-hmm.
So what should I do next? From an administrative standpoint, you do need to keep a record of the leave balance and any leave that is taken by employees. I know that a lot of the payroll systems are adding a facility to do this automatically. So if you use something such as Xero, that should be something you can do. Now, it's incredibly important to ensure that pay slips do not mention this type of leave is taken or any balances. And there's a reason for this, because if you have someone who is in a precarious situation where they may be in a situation where there is family and domestic violence, they haven't left yet, and they are using that leave in order to make arrangements to get themselves out of that situation, you don't want it to show on their pay slip that they've accessed that leave, or that there's a lower leave balance. So it's really important, for safety reasons, that is not the case. So you do need to update your policies around this particular type of leave in line with the implementation date. And I think it's important to ensure all employees do understand their entitlements in this area. I do know we had a bit of a discussion today within our team about how some of our clients are actually quite worried about this coming into play, that they're going to, well, this is just another 2 weeks leave employees are going to want to take that I have to pay for. I honestly don't think that is the case. I think you'll find that it's used very rarely. In fact, I can only think of a handful of situations since the unpaid leave came into play that any of our clients had someone utilise that leave. And the question has also come up about evidence, because you can ask for evidence that someone is entitled to take this leave. It's a paid type of leave. But I think that that's something you need to be very mindful about how you handle. If you have an employee that comes to you and says, I am in this situation, I need to access some of this leave to help get myself out of that situation, they may not be doing something that they can provide you with any evidence for. They may be going through that journey themselves, and they may be looking for somewhere else to live or those kind of things. So they might not have evidence to show you. And I think you have to trust people until they give you a reason not to. Mm. Now, if you're in a situation where you say you have an employee who has a history of just trying to use all their entitlements up, that comes to you and says, look, I need to take 2 days leave because I've got to take a family member to court, then it may be appropriate in that instance to say, well, can you provide some evidence that you attended court on that day with this person? They will provide that for workplaces. And so I think you need to consider every circumstance of that and be quite mindful of the sort of environment. You don't want to, if you've got a good culture where people feel that they can come forward and talk to you about these things, that's always going to be a good starting point, because then hopefully they'll be talking to you about them. And it may be more often than not that you're saying to someone, hey, this is here for you to use if you need it. Mm-hmm. So if you do need help navigating any of those particular issues, which can be a little tricky, again, that's what our team can help you with. So on to the next one.
So the next change we will discuss is sexual harassment. So this is part of the Respect at Work bill that was released last year. Essentially, there is a legal expectation that employers are proactive in preventing sexual harassment from happening in the workplace. So this protection will apply to employees, contractors, work experience students, volunteers, future workers, and anyone conducting a business or undertaking. So this includes anyone that deals with, for example, say a delivery driver experiences sexual harassment in another workplace. You still have responsibility there too. So you have to ensure employees know what is acceptable behaviour and what happens in that situation. So Fair Work will now hear disputes on sexual harassment.
Okay, so what should you do next? I think it's important to note that it's not necessarily changing what the current laws are around sexual harassment in regards to what is sexual harassment. What it is doing is putting a much bigger onus legally on employers to be proactive. It's no longer good enough to just wait until something happens and then deal with that situation. There is an expectation that employers will be doing whatever they can to prevent it, and they have to actively trying to prevent it. So what does that look like? You need to think about what you're currently doing. You know, is your policy something that you give to someone when they first start and then it sits on a shelf or in a drawer or online and no one ever accesses it? It's no longer enough to just do that. You need to be thinking about what you're doing proactively in the workplace to remind people about their behaviour. And one of the things that we do with clients, we do policy training with some of our clients when we first review their policy manuals, and that certainly ticks the box in proactively training people in that space. But we also do workplace behaviour training. I'm heading up to Sydney to do it with a client this Friday. So we would come in and we talk about the different types of behaviour, bullying, harassment, discrimination, and what that looks like, and you know, what is good behaviour. And it's really important that you update and implement your policies, particularly if you don't already have some, and that employees understand, one, what is acceptable behaviour, and two, what they should do if they experience it. Because as Kylie mentioned, this could happen outside of their actual workplace. It may not be that it's another employee, which is what most people think about with sexual harassment, but it could be a client, it could be a patient, it could be a customer, it could be someone, as Kylie mentioned, in another workplace. Often our employees don't just work within our own workplace. They might have to actively go out and visit other workplaces of customers or clients. And what happens when they're being harassed there? Do they know what steps that they are able to take? So it's really important that you proactively educate your employees on this. It's certainly that you're modelling what good behaviour is within your workplace is, you know, as always, really important. But what really has changed is that expectation that you're proactive as an employer. So you need to think about how you're going to be proactive and, you know, how you're going to make sure that your employees are not in this situation. We've certainly had a couple of cases across the last 12 months where either an employee was sexually harassed by another employee, but we've also had an instance where in a allied health environment, there was a receptionist who was being, for want of a better word, hit on by a couple of patients. One actually escalated quite badly, and you know, we had to have some discussions with the employer about what they could do in that situation. And I would really be thinking about not just what you're doing in your workplace, but what are you doing with partners or suppliers or other places, asking them what they're doing to be proactive in their workplace. Certainly some of our allied health clients who have had some of these issues recently have looked at putting in a charter of expectations, not just on how they interact with their patients, but on how patients need to interact with their staff, and setting those expectations with people who are coming into their business and saying, you know, we're going to provide this service for you, but by accepting that service, you're going to interact in a respectful way with our employees. So again, how can you be proactive and how can you ensure that you're meeting your obligations in this area?
Yes. All right. So at the moment, temporary shutdowns, such as over Christmas and New Year's period, they're not consistent across all awards. So this change will come into effect in May this year across 78 modern awards with the aim to provide some consistency. So it will restrict the ability of employers to direct employees to take unpaid leave during a temporary workplace shutdown. Now, if an employee doesn't have enough annual leave, there may be a requirement for payment. Although this new change has been announced, it's not really been finalised yet. So there may be possibly some changes before May this year. Next slide. So employers must provide employees with 28 days notice of the shutdown period. Employers may direct employees to use annual leave if available. And if the employee doesn't have enough annual leave accrued, the employee may take leave without pay or annual leave in advance. If an employee can no longer be directed to take leave without pay if they do not have sufficient annual leave available.
We know this is going to be one that causes a lot of grief for a lot of our clients. And I know there's already been a lot of discussion around it and rumours flying about what's in place and what isn't. And look, to be honest, until they finalise what the actual wording is going to be, and honestly, until some of that's tested in the courts, it may be a little bit watch this space. But I don't think that it necessarily will need, it just means I think we're going to be more mindful of how we manage shutdown periods over Christmas. So what could you be doing now? Well, you can start by considering the length of a shutdown period. We do have some clients in small businesses where the employer says, awesome, I want to go away for 4 weeks over Christmas, so I'm just going to shut the whole business down for 4 weeks. That may no longer be viable because people don't have enough leave to cover that period of time. Some of the things this may bring up for employees is how you actually manage leave across the year, because it may be now considered reasonable business grounds to say to someone, actually, I'm not going to approve you to take that much leave during the course of the year because you'll need to have that leave to take during the shutdown period. Or it may be that you need to make an agreement with that employee that they take leave without pay at that time and save their leave for the end of the year, or vice versa, that they agree by having that paid leave during the year that they will take any leave over Christmas that they don't have accrued as unpaid leave. One thing to really think about too is how you'll manage employees who start in the second half of the year. Even if you only have a 2-week shutdown over Christmas, you basically accrue 1 week of leave every 3 months. So if an employee starts in the second half of the year and you shut down for 2 weeks over Christmas, there is a fair chance that that person will not have enough leave to cover that shutdown period. So will you allow them to take leave in advance? It's never a great idea to have people take leave in advance, particularly in their first 12 months of employment. You may need to instigate a policy that says no one can take leave or access their leave in the first 6 months of the the second 6 months of the year if they're a new employee, or their first 6 months of employment. So I think this is going to be, as I said, we don't want to be definitive about what you should do at this point until they have actually released what the final wording is. For some people, their award might not change at all. They might already have similar wording in it. In others, it might be brand new. But one of the things that we suggest at the time it does come out is to review your leave policies in line with that. But also you might review contract clauses, because it may be possible, and again, this is still being debated and it's still being analysed by every law firm in Australia at the moment. But one of the options may be to be very clear in your contracts that you shut down for a definitive period. And it may be, instead of deciding every year what that is, that you have to be very clear about that up front and say, the expectation is that you will take leave without pay if you do not have enough leave do not keep enough leave for that period of time. I think it's going to be about communication. I think it's going to be about being more formal in how you think about it, that you don't get to December and go, oh, when are we going to shut down? Oh yeah, we're going to shut down for 2 weeks. That the earlier you do it, you might be able to negotiate and agree with employees about when that they have enough leave and how that's going to work. But it will be a little watch this space, and certainly we will keep you updated. If you don't already get our newsletters, I highly recommend that you jump on our website and sign up for the Punnet, our newsletter, because these will be the sort of things that we do update on. But I don't think it's all doom and gloom. I think the majority of employees, the majority of the time, are going to be happy to take leave without pay if they don't have enough leave, particularly if they want to use that leave at other times. And that's no different than what happens now. But there will be a requirement to be a bit more mindful about it. So if you do have employees that maybe do look for ways to get things in their favour, that, you might have to be really clear on how it's going to work in your workplace. Flexible work arrangements.
Stinks. So the main changes around flexible work arrangements effective 6 June this year is to include categories for family and domestic violence and pregnancy. So employers must carefully consider each and every request with the view to reach a workable solution. So all options and alternatives need to be considered here to try to find an agreement. If a solution cannot be reached, clear founded explanations should be provided within 21 days of receiving the request. So Fair Work Commission is able to hear these disputes if parties cannot resolve at workplace level. An employee may request a change in their working arrangements if they require flexibility because they are 55 or older, have a disability, are pregnant, are a parent, or have responsibility for the care of a child who is of school age or younger, are a carer, are experiencing family and domestic violence, or caring for someone who is.
So I'm going to go into a little bit more detail on this one because I think it's one that causes a little bit of confusion. And I think we need to be clear that flexible work arrangements are already in place for those other categories. It's just the two new categories that are coming into play. However, at the moment, there's not a requirement for you to have explored different options other than just saying, I looked at it and it's a yes or it's a no. There is now a higher level of expectation that as an employer, you won't just assess what someone has asked for, but that you've explored alternatives and other options that might be viable as well. And the burden of proof will be on the employer to prove that they went through that process. So first of all, I would be saying, do you already have a process in place for managing flexible work requests? Do you have a policy in place? Do you have a process for people making those formal requests? And often these requests don't come in formally. Often these requests come in very informally, and it's a discussion that's had, and no one, someone talks about it and then they just have a discussion. But if that person, once these new arrangements come in place from June, if that person's not happy with your response, you need to prove that that you've gone through that process and that you've considered things and that you've put other options forward. If it's all done verbally, that's going to be very difficult to do. So one of the things that we really want you to do is think about what the process you will put in place is if you don't have one already. The other is to consider the considerations for your particular business. This is going to be really unique for every business on what those considerations are. And it will be unique to every situation as well. It can't be a one size fits all. And I mean, we already say to clients when they have someone who asks for flexible work arrangements, to not just look at what they've put forward. You don't just have to say yes to what they've put forward. You might go back and say, well, I can accommodate 4 days a week, but 2 of those have to be these particular days. Or I can accommodate working from home on this day, but not this day. Like, it doesn't have to be exactly what the employee has asked for. And you can go back and forth, but you do need to consider all the information they've put forward. And you do need to be very clear on what process you went through to consider, particularly if you're going to say no. So in regards to a fair, flexible working policy, there's some principles that can be really helpful. One is that it should be mutually beneficial. So flexible arrangements should suit both the employee and the business. It's not a requirement. And the smaller the business, I guess, or I should say the larger the business, the more likely you're going to have to be more flexible to the employee. Because obviously, if you're an employer with 4 employees, it may not be as viable for you to be flexible with someone. But if you've got 10 people doing a particular role, one person going part-time may not necessarily have the impact it would on a tiny business. So again, it's going to be very business specific. Context matters. And by that, I mean a reasonable request will look different for every single business and every single individual. And what looks like a reasonable request today might be different to what looks like a reasonable request in 3 months' time. And that could be based on where the business is, the time of the year, the number of employees you have, where you are from a business. Are you in a growth phase? Are you in a downturn phase? All of those things, context will matter. And it will also matter the personal circumstances of the individual that is asking for flexible work. And this applies now. You can't just go a blanket no or a blanket yes. It should be leader-led. Ideally, senior leaders in any business should model a positive approach to flexible work. There's a lot of work being done in the last couple of years, particularly around flexible work, and people have by default during the pandemic had access to flexible work they didn't have before. And guess what? It's been proven that it can work. So even to be a good employer, even to be able to attract good people to your business, you might need to be more flexible in how you offer work. Your people managers also need to be trained. Now, if you're a tiny business, you might be the person someone comes to and has that conversation with. But if you have managers that work underneath you and you're the owner of the business, you need to make sure someone could be having that conversation with is very well trained on how to respond, that they don't just go, no, that's not an option, because that's not possible. They need to know how to handle a request. And our recommendation really is that if someone says, hey, I want to make these some flexible changes to my work pattern, or when I work on how I work, ask them to put it in writing to you, because then you get 21 days from the time they've put that request in writing to you. Ask them, particularly if they're being vague, go away and think about what you really would like ideally, or what you're open to, and pop it in writing to me. So then you've got something to reasonably consider. But make sure all of your people managers know that and what the process is in your business. And consider eligibility. It doesn't just need to apply to employees who are eligible under the law. In fact, sometimes that can cause disparity within a workplace. So why not open flexible work arrangements up to all your employees, regardless of the circumstances they're in? But you do need to be mindful of those that are going to be covered, or currently, or will be covered by the law in terms of making those requests. So when is it reasonable to refuse a request? Well, it has to be on business grounds. It can't just be if I don't want to do it, I don't believe in flexible work, I don't like flexible work. That's not going to cut it. So you could look at things like costs. So for example, if someone says, well, I no longer want to work during the week, I want to work on weekends, that might incur penalty rates. So that could be a reason, a reasonable reason to say no. If will it affect your supply chain? Will it cause delays in the business? Will there be an administrative cost of having to put someone else on to do that person's work? Again, that will depend on the size of your business to whether that's reasonable or not. And the other thing to consider is if you've had other employees that have already requested flexibility in how they work, you can't make a disruption to that. So if you've already got someone who's working part-time or has requested to work flexibly, and then someone else comes in and says, oh, well, now I want to do it as well, you do need to take into consideration that you can't remove someone else's request to accommodate that person that's now come forward. But every situation is going to be different. So it's really important that I would highly recommend, if it's not going to be a yes and you want to go down the path of no, that you have a very clear business case on why that is the case, and that you've looked at every alternative option before you just say no, and we can certainly help with that process. Mm-hmm. One thing to avoid too is that one size is not going to fit all. So the individual needs of the employee and the capacity of the business to accommodate should always be considered, and that's whether or not someone falls in one of those categories or not. It's not going to be the same for everybody, and the consideration level won't be the same for everybody. You might consider something differently for someone who says, hey, I want to go back and study, than you do someone who has a child with a disability. There's a different level of need and a different level of expectation on how much you would accommodate somebody. So you do need to be thoughtful of that. And you definitely want to avoid treating flexibility as a reward. Whether someone is going to be granted the ability to have flexibility shouldn't be linked to how long they've worked there, or their performance, or whether in their probation or anything like that. It's about their well-being and what works for the business. And sometimes the reason someone is underperforming, or the reason they are taking time off work, is because it's not working for them, and therefore they're asking for flexibility to fix that problem. So you really need to be careful that you don't withhold it from someone for the wrong reasons, or you don't use it as a reward for some other employees. And our last one we're going through today.
Fixed term contracts. So December this year, a fixed term contract cannot be extended more than once. So employers can no longer employ under a fixed term contract that is greater than 2 years or the sum of. So the contract will become permanent if the employer offends on this, and exceptions apply for training agreements, and if the employee is covered by an award that allows for fixed term contracts in the above circumstances. So a fixed term contract information statement is to be provided with new fixed term contracts, and Fair Work Commission will hear disputes on these requirements.
So it is important to remember this does come into play from December. So go to town before December. Having said that, If you're a business that currently uses fixed term contracts as a default, so there are some industries that have just it's become normal practice to have a rolling fixed term contract that you just every 6 months renew until you decide you don't want to. That's not going to stand up anymore. You're going to have to really rethink on how you do things and what other alternatives you could consider. And look, to be honest, this is coming into play as to address issues in some particular industries, but also courts have already looked at this over the last few years and said, hey, if this person has been in a consistent role and you just keep trying to use this fixed term and suddenly for no particular reason other than you decide to, you stop it, they're actually going back and examining what's happened in practice and saying, hey, that was a permanent employment contract anyway. So really, this is just making it abundantly clear to everybody. So if you do have a business that really relies on this, it's time to rethink it. But really, they're still going to have their place. They're going to have their place for if you need someone for 6 months to do a particular project, or you need to have someone coming into your business that is going to do a maternity leave replacement or something like that. They will still have their place, but they are not going to be the default in industries anymore. And this is what this is coming to address. We want to leave plenty of time to answer questions this evening, but I will say that there are plenty of resources about this on the Fair Work website. It's gotten more user-friendly over time, but having said that, if you want advice that is really specific to your circumstances, our team is available to help you navigate through that. Before we open up for questions, I do also want to mention that we have some upcoming training around leadership, which might be helpful if you have to have tricky conversations. We've got one in Newcastle late next week. You can still register till the beginning of next week. We've got one in Torquay later in March, and we've also launched one for Brisbane on May the 4th. So anyone that attends that, given I'm a bit of a Star Wars nerd, get ready for lots of Star Wars references for that whole day because it will be May the 4th. We also have some oncoming online mental health first aid sessions, as well as a in-person 2-day session in June in Torquay. And you can get all the information on our training courses on our website. If you have been a client of Strawberry Seed in the past and done one of our packages, or a current client, you can also access discounts to attend these sessions. So please reach out to our team and we can hand you some codes if you need them. Also follow us on socials. We do share articles all the time, particularly on Facebook and LinkedIn, about these topics, about the laws that are coming in, about recent cases. So it can be really handy to keep up to date with what is going on. Finally, I'm going to open up for questions. So I'm going to open my Q&A box, and right now I have no questions there. So surely there are some questions somewhere out there from somebody that they would like answered. Whoops, trying to get my other chat box up just in case someone had put some questions in there. Does anybody have any questions that they would like answered at this stage? I'll be disappointed if we don't get any. We normally get heaps of questions. I do realise that, for some of these things, until they are actually implemented and they're coming into play, it will be hard to know how it will impact you. I think there will be different industries that are impacted in different ways. And certainly we're doing a lot to communicate with our clients at the moment on, for those that are support clients, on how we're implementing these changes on their behalf as well. Oh, there's so much time for questions and no one's going to ask us anything.
We must have been very thorough in our presentation.
We must have been. Look, I will say that as these sort of start to get implemented and you do have questions, our team are doing a lot of PD at the moment to keep up to date with the thoughts and what's happening in these particular areas. Whenever there's changes to the Fair Work Act, there's always going to be some ambiguities. There's going to be things that aren't considered. We recently had an issue with Fair Work as recently as this week, where we were having it escalated with Fair Work and still didn't get a straight answer. But, we're going to be doing our best to keep you informed. If you do follow us on the socials, or you do get our newsletter, then you will also get updates from us as these things are being implemented, reminding you of the things you need to do. But it looks like there's not a lot of questions tonight. Well, so what we might do is we will stay online for a few minutes. So if anyone does decide that they've got a couple of questions that they might want to ask, we'll stay online for a few minutes if you want to stay on and ask it. Oh, does SS contract templates have the pay secrecy clause in it? Yes, it does. Or pretty much every single contract template that existed before December probably has a pay secrecy clause if it was written well, because that was considered a standard clause. So as you read through the confidentiality and, the expectations clause, I can't think off the top of my head exactly. Can you remember which clause it is in most contracts, Kylie?
It was around remuneration, confidentiality, I think was it the duties? No, I'm not too sure.
Yeah, it definitely is in any contract templates we have done up until now, essentially. So have a read through it.
If you search remuneration confidentiality, it'll bring up where it is.
Yeah. So it is definitely a clause in there. We can give you a hand to find that if you reach out to any of our team. But yes, it does have it in there, and we have been slowly with our support clients going through that process. They've been, updating it for them. Under employer duties, Frances Orr has just jumped on and answered that question for us. It's handy when you have team members that are on there. So, it is under employer duties. So it can be, if you've got an existing contract template, you can literally just remove that particular clause before you give it to any new employees. We also have changed the wording in our confidentiality agreement slightly as well, to make it clear that there is still a requirement, and it's going to be interesting with that, because there's still a requirement to be confidential in terms of outside the organisation. They're not required to, they shouldn't be disclosing that to people outside the organisation, that they don't need to. But we've reworded it so it's clear that that excludes, sharing that with other employees. Are there any other questions that anyone would like answered on any of the topics we've covered today? And hey, we've got time, even another topic that we haven't covered, or a topic that you'd like to have covered over the next few months.
Yes, ideas for next webinars.
Yeah, we will have the next one in, what are we now, February, in the end of April will be our next one. And then I can guarantee you our June one, as always, will be about award increases, because that's what we tend to cover, and look at any other changes. And I think the other thing is to understand that there are often changes constantly to awards. I know the Professional Services Award has got some changes being reviewed at the moment, so it's not uncommon for changes to happen across the year. We do have another question. Paid family and domestic violence leave, does this roll over at the end of the year, end of financial year, or employee's anniversary? Employee's anniversary. It's every anniversary for that employee that rolls over. It's not done on a calendar year or end of financial year. It is on the employee's anniversary. It's a good question. Thank you for asking. Do we have any other questions? At least we've got a couple of questions. I feel better that we have a couple of questions. Look, some of these issues are quite specific to your industry and your business, and often can be quite sensitive, particularly around things like domestic violence or sexual harassment and things like that. So, there is an element of confidentiality that also needs to be kept. So it is important that we, you often get advice that is specific to a certain circumstance. And I think in terms of policies that you implement, you want to make sure that they're not, this is the answer. It may be, well, this is the process we follow. Well, thank you to whoever just wrote that we've been very comprehensive and nice and clear, no questions. Thank you very much, everyone. As I said, we'll hang around for another 5-10 minutes if anyone does have any other questions. Otherwise, we will be sending out a recording of this over the next period of time. Over the next few days, you'll receive a recording, hopefully tomorrow, of this, and we'll also have a copy of it on our website if you do want to watch it again in the future. So thank you everyone for attending, and thank you Kylie for your first webinar with Strawberry Seed. Thank you so much for your help.
Absolute pleasure. Thank you.